everyone. Happy spring, happy March. So happy to see you all today. Welcome you joining today's class, Common Estate Planning Mistakes. I'm Pauline Lam from Kota Realty, your 2021 co-chair, Education Committee, West and Gabriel Valley Realtors. A friendly reminder, all participants will be muted in the meeting. And should you have any questions, please enter it into the chat box. Speaker will answer it during the Q&A section. This meeting is being recorded and will be available on the YouTube channel, West and Gabriel Valley Realtors. Now I'm so happy to invite our Education Committee member, Mario Manzianina, to introduce our special speaker, Attorney Paul Velasco. Mario, the floor is yours.
Well, thank you so much. I really appreciate for this privilege to introducing Mr. Velasco. And with that in mind, I will say that Mr. Paul Velasco is the founder of the Velasco Law Group. Mr. Velasco has been practicing for more than 22 years and focuses in the practice exclusively on estate planning, probate, and trust administration, as well as probate and trust litigation. With that in mind, I would like to pass to Mr. Velasco to start his wonderful presentation. Thank you, Mr. Velasco, and look forward to hear all of the mistakes for estate planning. Thank you.
All right. Thank you very much. Thank you, Pauline, and thank you, Mario, for that nice introduction. I appreciate the opportunity to speak with you all. As both Pauline and Mario said, I'm a certified specialist in estate planning, probate, and trust law. This is all I've done my entire career. We have offices in Long Beach, Downey, and Irvine. There's about 22 people in the firm, 7 attorneys, and we're all dedicated exclusively to this area of work. I'm going to share my screen now and just let you know just kind of what I do. Let me get to my PowerPoint presentation. All right, hopefully everybody can see that. And let me start from the beginning. All right, so a big part of my practice, of course, is estate and tax planning. So meeting with clients, talking about trusts and wills and powers of attorney, talking about estate planning and the importance of it, making sure that everybody understands why they need to do it, and then helping them to implement the plan based on their family and financial circumstances. But a big part of my practice, I would say probably more than 50%, deals with court work as it relates to trusts and estates. It deals with court work because most people don't do estate planning. Most people in California, or in really the entire United States, 65% of Americans don't have any written plan in place for the administration or the distribution of their estate at their death. And so because of that, in California anyway, you end up going through probate. So most of the situations I deal with are situations where families are coming to me because their parents or other family members didn't do a trust. And now we're having to go through the probate process, which we're going to talk about in detail in just a moment. We also represent trustees and executors in those processes to make sure that they carry out their duties and responsibilities. The other thing that we do is trust and estate related litigation. So when things go wrong, when there are problems with the estate, when beneficiaries are fighting with one another, when they're contesting wills or trusts, or in situations where maybe the person who died tried to do some estate planning and they just got it wrong. They didn't do it right. You know, nowadays people can go online, they can go to LegalZoom and Rocket Lawyer and other online software, and you can do your own trust and you can do your own will, and many people attempt that. Other people will try to go to paralegals like We the People and other document prep companies that purport to know how to do all these things. And they don't realize when you try to do things yourself, or when you're doing it with somebody who doesn't really know what they're doing, and you think that you're saving money by not going to an attorney, you don't really know. You'll never know really whether those documents are done correctly. The way that people find out whether they're done correctly is by people pass away, right? It's normally when you sign a will or a trust or powers of attorney, you sign those documents and you put them away. Hopefully they'll collect dust for many years and you won't need to use them, but eventually they will be needed. Somebody passes away and that's when the documents are brought out and attempted to be used. And it's usually only then that you discover that there's a problem with the documents, right? Either there was a mistake that they made when they tried to do it themselves, or the people who did the documents There's so many areas that you can make mistakes, so many pitfalls that people are just not aware of. And so now we end up going to court. Now we're spending not thousands, but tens of thousands of dollars dealing with problems, dealing with situations where because there's a problem with the documents and the person is now deceased, those documents become irrevocable and they can only be changed or modified or corrected by a court. And sometimes when we're in court, if you interpret the document one way, it may help one beneficiary or one side of the family. And if you interpret it another way, it helps other people. And so now people are lawyering up to try and resolve whatever the problem is. And so it's so important that if you're going to do, just like anything else in life, if you're going to do estate planning or if you're going to do anything like that, just do it right. Go to an attorney who knows what they're doing, who specializes in this area of practice, and get it done. So I'm going to talk to you, I'm going to lay the groundwork for estate planning and just talk about the importance of it, why people do it, what are the goals, what are some of the documents that people use. I want to give you a basic background so that we're all on the same page. And then I'm going to spend most of my time talking about the mistakes that people make, the problems that they create for themselves, and what are some of the most common mistakes and ways that we can correct those mistakes if it's done properly. So let's just talk about the goals and objectives. Why do estate planning? Why is it so important? Well, the first reason, of course, is that you should get to decide where your property goes when you pass away. You should, in writing, be able to determine who are going to be your beneficiaries, who are going to be the people who are going to inherit from you. If you don't do anything, what most people don't understand is that you do have a will. Either you've done it yourself or the state of California has done it for you. In the probate code, it says when people die without a will or a trust, these are the people who will inherit from you. It makes a list. Now, it may or may not be the people that you would have chosen, but why would you ever leave that up to the state of California? You should get to decide that. And the only way that's going to happen is if you have it in writing, if you do your own will or your own trust. So that's the first goal. You get to decide where your assets go when you pass away. The second goal of estate planning is to ensure that the people that you've chosen, whether they're your children or grandchildren or other beneficiaries, that they receive it in the right way, in the appropriate manner. What do I mean by that? Well, let's say that you have children or grandchildren who are inheriting from you and who may be very young. The likelihood, of course, is that by the time you pass away, your beneficiaries will now, hopefully your children will be adults, have families of their own, and there won't be any issues about them being too young. But what if something happens to you unexpectedly? And now people who are inheriting from you are young. Do you know the age at which in California, at which somebody is now legally entitled to manage their own financial affairs? The age is 18. 18 is when people become adults in California and capable of signing contracts and managing their own affairs. Well, I don't know if you've seen an 18-year-old with a bunch of money at their disposal, but I can tell you I have, and it's not a pretty picture. Money just does not last long in their hands, often because of their immaturity and their responsibility, but also often because people take advantage of them. People who are older, maybe family members or so-called friends who are looking for loans because they know that the person has come into a bunch of money. So before you know it, that money's just gone. So it's so important then to avoid that problem. The way you avoid it is by having a trust. In a trust, you can set the age at which your children or grandchildren or other beneficiaries will inherit from you. What age would that be? Well, you get to decide that, right? I remember when I did my trust, I put the age of 25 for my children, that if something happened to me unexpectedly, they wouldn't get control of it until they reached the age of 25. And when my oldest daughter turned 25 a few years ago, I changed that to 30. So it's just really, you've got to make sure that for your family circumstances, what would be the best age, right? And so before then, if something happens to me, I've named somebody who I trust, who I know, who I believe is going to manage things for their benefit until they reach the age that is appropriate. So that's how you would set it up. What about beneficiaries who are receiving government benefits? Do you know that if for many people who are receiving government benefits, whether it's SSI or Medi-Cal or disability, that depending on the type of benefits they're receiving, if they receive an inheritance directly from you, they may be disqualified from those benefits, right? Some of those benefits they're receiving are based on need, financial need. And if now they're receiving an inheritance, they may be disqualified. But there's a way that you can actually still give money to somebody who's receiving government benefits if you set it up in your trust correctly as a special needs trust. So you can still leave money and property to somebody who's receiving government benefits. It just has to be done in the correct way. But if you don't do anything, if you don't do a trust that allows you to do that, and you pass away and you're, because they're an heir, property goes to them, they may be disqualified from those benefits. So best to set it up correctly. And again, the only way to do that is to have a trust or an estate plan that does that. So that's another goal, making sure that not only that the beneficiaries you want receive it, but that they get it in the right way, in the appropriate manner, in a way that protects them. What about the next goal? And that is to choose the right person who's going to have control over your financial affairs if something happens to you. This is where you get to pick your executor, you get to pick your successor trustee, the agent under your power of attorney, or your healthcare agent. All of these people are going to make decisions for you in the event that you reach a point in the future where you're no longer capable of managing your own financial affairs. Statistics tell us that most people will experience some period of convalescence before they pass away. You may have an accident or an illness or Alzheimer's or dementia or some other condition that will require somebody else to step in and manage things for you. Well, if you don't do anything, guess what? That's the very first fight in court among your family members, is who's going to be in control of the estate, who's going to be in control of the money. People don't trust each other. And so now somebody files a petition to be appointed as the administrator, and then another files a competing petition. And so the very first fight in court where people spend thousands of dollars is who gets to be appointed. So you can take that off the table. You can avoid that fight if you have a plan in place that determines who is going to have those choices. Who you want as the first choice for your executor, your successor trustee. Who do you want making healthcare decisions for you? So that way we minimize those conflicts among your family members. You get to decide that by having an estate plan in place. And what would be the characteristics of the kind of person you would want in that position? Think about it. One of the most common areas of litigation in probate and trust litigation is fiduciary litigation. This is situations where I'm having to go after trustees and executors who are not doing their job, who are mismanaging sometimes the estate, who are misappropriating money that doesn't belong to them, who are just not following through with their duties and responsibilities. I get calls from beneficiaries all the time who are saying, you know, my brother's the trustee of our parents' trust. My mom passed away a year ago, 2 years ago. They're not doing anything. They're not giving us information. They're not providing us with a copy of the documents. And my brother's living in the property and he's not paying rent. You know, what can we do? So then we end up having to get involved and sometimes filing a petition to remove those people and get somebody else appointed in there. So these are the things that happen when you don't choose the right person. So it's really important. Who would you choose? Well, somebody that has, you know, honesty and integrity is number one in my book. Somebody who's honest, who's going to follow through with your wishes, who's going to carry out your instructions, who communicates well with other people, who is fair-minded and just has common sense, right? That goes a long way. It's interesting to me, common sense is really not so common. If more people had that, there would be less problems in my world. Unfortunately, that's not the case. So choosing the right person is going to be very important to minimize problems or disputes in the future. The other thing is maximizing the amount that ultimately goes to your family. That's another goal of estate planning. The only way that can happen is if you have an estate plan in place, a plan that says where everything goes when you pass away and that chooses the right people to do that. Because by doing that, you're going to avoid probate. You're going to minimize court costs, filing fees, executor fees, attorney's fees, all of those expenses and costs are going to be minimized. That means more money will pass to your family if you plan correctly. So these are the goals. This is what we're trying to do by doing estate planning, right? So what are some of the options out there? What are some of the tools that people can use to do estate planning? Well, there's one thing that you may not think of as estate planning, but people use it in this way. It's not a very good plan, but people use joint tenancy as an option for estate planning in place of a trust or a will. People add their children or other beneficiaries to the title of their residence or to their properties or to their bank accounts or stocks or investments, because joint tenancy, as you know, is a manner of holding title to something. The most important feature of a joint tenancy is the right of survivorship, right? So if you hold property with somebody as a joint tenant and one joint tenant passes away, automatically by operation of law, the property passes to the surviving joint tenant or joint tenants if there's more than one. There's no need for a probate. You don't have to do a will. Just by the way that you took title, automatically it passes to the survivors. So this is a popular thing. People use this all the time. So let me tell you why joint tenancy is the worst way to take title to things, right? Here are the problems with joint tenancy. And I'm going to talk to you about them in the context of cases that I've had to deal with where joint tenancy was the problem. So let me talk to you about a client of mine who came to me. She had come to me because she had put the property, she had added her children to the title of her property. Her husband had passed away a couple of years prior to the time she came to me. He passed away unexpectedly. He was not well, he was ill, and she was not in good health either. And so she had asked a friend about what she should do. She was concerned about probate, and this friend advised her to add her sons to the title of the property as joint owners, as joint tenants. By doing so, if she passed away, the property automatically would pass to them. So unfortunately, she took that advice and found a paralegal who could help her with a quitclaim deed and just added the children to the title, her two sons. Well, about a year after that, one of her sons was involved in a serious motorcycle accident, and he was left in a permanent vegetative state. It was very tragic, but he was unfortunately was not capable of making decisions for himself anymore. He couldn't sign, he couldn't do anything. So now she, about a few months after that, she decided that she was going to have to sell or refinance the property. Medical bills were piling up and she had to do something. Well, because she had added him to the title and he was no longer capable of signing, she was not able to do anything. So that's when she came to us, and we ended up having to establish a conservatorship for her son. A conservatorship is a probate, is a proceeding that happens in the same court that probates happen. So it's often referred to as a living probate because it happens while the person is still alive, but just unable to manage their own financial affairs. So this way we got her appointed as the agent, but it took about 8 months to do that. And it cost her about $8,000 to set that up. And that conservatorship will last as long as he is incapacitated for the rest of his life if he has assets. So what ended up happening is once we established that for her, she could then sell the property, which she did. She sold it, and then 1/3 of those proceeds from the sale ended up going into the conservatorship because her son was on the title and the court viewed that as his property. Now, she did not intend, when she added them to the title of her property, she did not intend to give them a title or rights immediately. She thought that that would take effect only at her death. And that's what a lot of people believe. They just misunderstand the fact that when you're adding somebody to the title of your property, you're giving them rights today. They have ownership with you. And so whatever their problems may become in the future, whether it's this, where you have somebody who became incapacitated, or a child who's going through a divorce. I have another client who added her daughter to the title of a couple of her properties. And again, same reason, just in case she passed away, the daughter would be able to receive it without going through a probate. But now that daughter was going through a divorce, and that property is pulled into the divorce, and the husband is trying to claim some interest in those properties. So you can see that these reasons are reasons to avoid adding people to title. It happens with bank accounts too. I had a client who came to me one day, and the problem was that she called me actually in a panic because from one day to the next, her bank account had been drained. She had a pretty large account at her bank that it had over $100,000 in it. And she went from one day to the next, it was just empty. She saw her statement, there was no money in it. She thought she was the victim of fraud. But when we got involved and contacted the bank, we ended up finding out that no, she wasn't the victim of fraud. What ended up happening was she had added her son to the title of her account, and he didn't take the money. But what had happened is that he had a judgment against him from 2 years prior. Somebody had filed a lawsuit against him and got a default judgment. And then they found this account that he was now entitled to, and they issued a levy at the bank to collect on that judgment. Now, the bank is supposed to notify my client that a levy is coming and give her an opportunity to defend it. Well, she didn't get the notice. So ended up the levy was issued and the creditor got all of that money. Now we were able to get involved and show that that money did not belong to the son, and therefore it was not right for them to take it. We ended up settling with that creditor, got most of the money back. Some went to pay them off, some went to pay my fees. Fortunately, she didn't add her son to the title of her residence, which she was going to do also, because if she had done that, that judgment would have attached to that property as well. So you can see all these problems. When you start adding children to the title of your property, their problems, as I said earlier, become your problems. Another situation, common situation, is where parents add children to the title for one reason or another of their property. I'm dealing with one right now where they were concerned because the father was in the hospital and his medical bills were accumulating, and he was concerned that the hospitals would come after him someday for his property. So he ended up transferring the property to one of his children and putting him on title. This happened about 10 years ago. And now he was calling the property back. He was saying, okay, we want you to give the property back, son. And the son is now refusing, is saying he's not going to give it back. And so now we're left with a situation where parents have to sue their son to get the title of their property back. So you can see that all the different problems that can occur. Let me tell you one last problem, and this is with respect to husbands and wives. Because I know that when husbands and wives take title, when you're representing clients who are buying a property together, who are married, I think that the most popular way to take title, even to this day, is still joint tenancy for husbands and wives. So let me tell you about a problem in a situation with a case where the client came to me and it ended up being a very bad consequence for her. So let me give you a little bit of some background first, explain some important tax concepts before I talk to you about the client. So as you know, when you buy property, so if I were to buy a property, let's say I purchased property for $500,000, and some years later, it's now worth $1 million, right? So if I've invested in property, when I buy that property, that $500,000 investment becomes my basis. That's my basis for determining capital gains in the future. It's my tax basis. If I sell the property in the future for $1 million, I'm going to have a capital gain. So the gain is going to be the difference between what I paid for it, my basis, and what I sold it for, right? But what if instead of selling it, I gift it to my children at my death? So at my death, my children inherit it through my trust. The question becomes, well, what is the basis in their hands? What is the tax basis of that property for them when they go to sell it in the future? Well, they got a stepped up basis. Their basis is not what I paid for it. It's actually the date of death value. When I pass away and leave this to them, if it's worth $1 million, that becomes their basis for determining capital gains. So getting a stepped up basis at the death of somebody when you leave property to your children is a very important concept. If my daughters were then to sell the property right after I passed away, there would be zero gain. Now, husbands and wives, when the first spouse passes away and leaves property to the survivor, if it's community property, the survivor gets a 100% stepped up basis on the value of the property. So now the survivor could sell a property if they wanted to without paying capital gains tax right after the death of the first spouse. So getting a stepped up basis for community property is important. So here's the case. My client came to me one day. She came to me and she was referred by her CPA, by her accountant, because she was going to sell her property. Her husband had passed away 1 year prior to the time she came to me, and she was now going to go live with her daughter. And she wanted to sell her residence. They had a residence in Rancho Palos Verdes that they had purchased many, many years ago, probably 50 years ago, for $200,000. And that property was now worth several $1 million. So she wanted to know when she sold it, was she going to have to pay capital gains taxes? So we pulled the title for the property, and how do you think it was titled? Joint tenancy with right of survivorship. Well, unfortunately, the IRS does not recognize joint tenancy property as community property, even though under California law, it is certainly community property. If this couple were to get divorced, the court would divide that 50-50 because it was acquired during the marriage, and that's what community property is. But the federal government is not bound by state law. They don't have to look at the state law and say, oh yeah, this is community property. No, they want to see something that says it's community property. Now, if its title isn't taken that way, then they need to see some agreement or something in writing that shows that. In this case, she had nothing like that. It was held as community property. So she did not get 100% stepped up basis. She only got a 1/2 step up. His half, her husband's half got stepped up, but her half, her basis stayed the same as when they bought it 50 years ago. So when she sold the property, she ended up paying several $100,000 in capital gains tax, all because the property was titled as joint tenants rather than community property. Now, I'm not telling you this that you can tell all your clients, oh, take everything as community property. No, that's not your job to do, right? I'm sure people ask you how they should take title. Well, you don't want to create a situation for yourself where because of your advice, they are now coming back to sue you some years later because they're getting divorced and it really wasn't community property. So it's not really your job to do, but now you understand what the potential consequences are when people are talking about taking title that way. So you can tell them, well, first of all, it should also tell you that they don't have a trust. If they're telling you they want to take title as joint tenants, They don't have a trust, and they should if they own real estate. Number two is now you know that there are potential adverse tax consequences to taking title as joint tenants, and they should speak with an attorney or some other professional advisor who can tell them some of the best ways under their circumstances, a better way to take title. So that's what happens with joint tenancy, and why, in my opinion, it's the worst way to take title to things, okay? All right, now look, there are exceptions to every rule, which is why you're not to go out and just tell everybody, hey, don't do that. Best to speak with a professional advisor, with an attorney. All right, so what are the other options? We know joint tenancy is not a good option for estate planning. What about a will? Well, a will, as you all know, is simply a document that expresses your wishes about where your property goes when you pass away. It's very simple to do. You can write your will and you can leave it your property to who you choose. In a will, you also name an executor, the person who's going to have control of your estate when you pass away. So a will is better than nothing because a will serves those two purposes, right? That we talked about. Remember, we talked about two of those purposes for estate planning. The goal is you get to leave the property to who you want, and you get to pick your executor. Well, here with a will, you can do that. What's the problem with a will, though, of having only a will? If you have only a will in California, wills are subject to probate. So the will is still going to get probated. And that's what we're trying to avoid. So you don't want to do just a will, because a will is going to have to go through probate. The word probate comes from the Latin verb meaning to prove. You have to prove that the will is valid, that it was properly executed, that it was properly witnessed. And that is done in court, in the probate court. So if all you have is a will, you're still going to go through probate. So let me talk to you a little bit about the problems with probate. Why are we trying to avoid probate? Probate actually serves a good purpose. The purpose of probate is to ensure that when you pass away, your final affairs are settled, that an executor is chosen to get control of your assets, to pay off any debts, taxes, or expenses you owe, and then to distribute the property to the people who are entitled to it, either by the terms of the will or by the probate code. If you die intestate, the probate code says these are the people who are entitled to it. So those are good things. The problem is that in California, probate is the most time-consuming, costly, inefficient way to deal with the administration of an estate. There's a better way. So here's the problem with probate. Number one, it's an open court proceeding. Anybody can go down to the courthouse, literally anybody can go down to the courthouse, pull the title to what you have, and or pull the probate file actually, and see what you own. They can see all the assets that are in your estate. They can not only see that, they can see the names and addresses of your beneficiaries, of your heirs, of people who are going to inherit all this. All their private information is there. So nobody really wants to air their dirty laundry in public, so to speak. But if there's any fighting going on or disputes among the family, it's all in there as well. You know, those shows like TMZ, those news magazine shows like TMZ and others that have all these salacious details about celebrities and their estate and their divorces and Britney Spears and her conservatorship. Much of that information is gleaned from the court files. So not a pretty thing you want to go through. So you want to avoid it just for that reason alone. The other thing is that probate happens in court. What do people do in court? They fight. There are disputes that happen in court. People lawyer up. They fight with one another and spend thousands of dollars in court. Probate is no difference. Probate is a court as well. And it's a place where people's disputes can get resolved, where people can file petitions against one another, where third parties can file a creditor's claim against the estate for money that they believe the decedent owed them. Credit card companies, Medi-Cal can come in and file a claim against the estate. All kinds of things can happen in a probate, so we want to avoid it. The third thing is time delays. It now takes over a year to go through a probate, probably closer to 18 months to finish up a probate from beginning to end. And your beneficiaries are not going to get anything until the end of the probate. And sometimes that can be a financial hardship for your family to have to wait a year or 18 months to get anything. The last thing is that probate is expensive. It's expensive to go through the probate process. Most of our revenues are derived not from estate planning, we do, right? Because we don't charge a whole lot of money for that compared to what we get in a probate or where litigation is going on. So probate is expensive. How are the fees calculated? The fees are calculated based on a sliding scale. The larger the estate, the higher the fees. In the probate code, what it actually says is that the attorney's fee and the executor's fee is 4% of the first $100,000. 3% of the next $100,000 of value, 2% of the next $800,000 of value. As you can see, it's a sliding scale. So I pulled out some numbers to show you, if all you had is a house in California and you're just going through probate, the fees for a $500,000 estate are $13,000 for the attorney, $13,000 for the executor. So now you're at $26,000, and that's just for the fees. There's probably about $4,000 or $5,000 in court costs. So now you're over $30,000 just to probate an estate. And by the way, if that property had a mortgage against it, say it was a $300,000 mortgage, they don't deduct for that to establish the fee. The fee is based on the gross value of the estate, the $500,000, even though the net value is much less than that if there's a mortgage. The other thing is that this is not even all the fees. If there's fighting going on, if there's extraordinary services that the attorney has to provide, what they call extraordinary services, that's when there's litigation going on, when the attorney's having to defend against claims being made against the estate, when there's a property that's being sold and the attorney has to be involved in the sale. All of these things are extra that the attorney and the executor can charge for. And sometimes those fees are even larger than that $26,000 fee here. I was involved in a probate once where my statutory fee, based on the size of the estate, was only $7,000. But my extraordinary fee, because of all of the litigation that was going on, was $32,000. You can see that these fees are onerous and something you want to avoid if you can. And how do we avoid probate then? You avoid it by having a living trust. A living trust is a will substitute. It does the exact same thing that a will does. It allows you to name the beneficiaries who are going to inherit from you when you pass away. All trusts have three key positions within them. Creator of the trust, often referred to as the settlor, the trustor, the grantor. It's the creator. All trusts have to have a creator, of course. All trusts have to have a trustee. That's the person who has all the power and authority over the trust assets, the power to invest the trust assets, to spend the trust assets, to purchase property, to sell property, to distribute to the beneficiaries. That's the person who has all the control. And the third is the beneficiary. That is the owner. The beneficiary is the one who owns all the assets in the trust. So what if I was going to create a trust? What would that look like? Well, a trust is simply a contract. It's an agreement. For a married couple, you're making an agreement with each other, right? To hold your property according to the terms of the trust. If it's me, if I'm a single person, I'm just putting property in trust, it's a contract with myself, essentially. And what I'm doing is this, I'm creating this trust. So let's say that I create the Paul Velasco Trust. And in that trust, I put provisions for where everything's going to go when I pass away. But the trust controls things not just at my death, it's also going to control things during my lifetime. So when I create this trust says, look, I'm creating this trust, and it's not enough just to sign the trust and put it away. You have to fund the trust, fund it. You have to transfer the title of your properties into the trust. So your properties, your real estate, all have to get retitled from your name into the name of the trust. We do deeds, we record deeds with the county that puts it into the Paul Velasco Trust rather than just in my individual name. If I die with things in my name, it's subject to probate. If I die with assets in the trust, it avoids probate, right? So in that trust, if I put my real estate, my investments, my bank accounts, my business interests, my LLCs, my corporations, if I have life insurance, I'm going to name the trust as the beneficiary. If I do all that, if I put a trust wrapper around everything, now I'm going to avoid probate. Now, when I pass away, that trust is going to control everything. And in that trust, I've named a successor trustee. I'm the initial trustee. So when I create a trust, I occupy all three positions. I'm the creator, the trustee, and the beneficiary. Why? Well, I'm not doing anything with these assets yet. I'm not giving them away to my children yet. They're still mine. So that trust during my lifetime simply says, I'm putting it all in a trust, but the trust is still mine and I can do with it whatever I want. I can spend it how I choose. I can sell property in and out. I'm not really going to notice a difference in the way that I deal with or manage or pay or file my tax returns. Nothing really changes except the title of things. And that's it. And that trust will now control when I pass away. My successor trustee will literally be able to take, when I die, that trust document to the bank, get control of all my bank accounts that are in the trust, record deeds that give them control over the real estate, collect life insurance proceeds where the beneficiary was the trust. All of these things are done with that trust document. We don't need to go to court for anything. A living trust avoids probate because of that, for those reasons. That's how a living trust works, and that's how we avoid probate. So if we compare a trust and a will, what is the main differences? The main difference is that number one, a living trust avoids probate. You don't have to go through probate. If you did your trust correctly, if you created the trust correctly and you put your assets into the trust the way you're supposed to, which I will tell you is a big mistake that people make, which we're going to talk about in a moment, because they don't do that. They don't properly fund their trust. We'll talk about the consequences of that in a moment. But if you do it right, a living trust avoids probate. It also avoids a conservatorship. What if instead of passing away, I become incapacitated, I have an accident or an illness, and I'm no longer capable of managing my own financial affairs? Well, my trustee, with a doctor's letter of incapacity, will now have control over my assets, can step in, manage my property for me, pay my bills, deal with Social Security, file my tax returns, do whatever needs to get done. By having a trust, we avoid a conservatorship. A trust avoids Medi-Cal claims. Medi-Cal claims. Remember I said that if you're going through probate, Medi-Cal can file a recovery claim in the probate. Those claims can often be very large because if the decedent was receiving government benefits for many years, then Medi-Cal can request a recovery of all those. And sometimes it's the largest claim of the estate. Sometimes it wipes it out completely. I've had claims of more than $300,000 in a probate. So if your assets instead are held in a living trust, Medi-Cal cannot make a claim against those assets. So trusts avoid Medi-Cal claims. And then it makes it more difficult for creditors to collect, even credit card companies or hospitals that are trying to collect from the estate. If your assets are held in a trust, it's much more difficult to do than if it's in a probate. If it's in a probate, the creditor simply files a form in the court saying, I want to get paid. And the court requires all creditors' claims to be paid before the estate is distributed. And then privacy. Remember I said in a probate proceeding, anybody can go down to the courthouse and pull your file and see what your assets are, see who your beneficiaries are, their names and addresses, all their contact information is there. That's not so in a trust administration. When somebody dies with property in a trust, only the trustee and the beneficiary have access to that information. So it's a private administration. So these are the reasons why we want to do a living trust, right? So now I think hopefully you have a better basic understanding of why it's important to do estate planning, what the goals are, and then why we're doing a living trust instead of a will, okay? All right, so before I move on to my next topic, which is, you know, the old adage, what you don't know can't hurt you. Well, that's definitely not true when it comes to estate planning. What you don't know can and will hurt you and your family if you don't correct that problem. So we'll talk about that in a moment. But before I do, I know that there's some questions here, and let me see if I can answer some of them. I may be able to get to all of them because I want to get to some of this other information that I want to share with you. Let me see. All right, so scroll down. How much is the maximum gift amount per year in California for one person can gift to other people? So the maximum gift amount, well, there's two types of exclusions, two types of amounts that you can give away. One is what's called the annual exclusion. That's the amount that you can give away tax-free to any person, children, family member, non-family member, to your attorney. Hey, hello. You can give $15,000 to anybody without having to report it to the IRS, right? What if you give something more than $15,000? Well, everybody also today, under the current law, can give away a maximum of $11.7 million tax-free. 11.7 million. That's either during lifetime or at death, right? 11.7 million. So if I gave my children $1 million today, I wouldn't have to pay any estate taxes or gift taxes. They wouldn't have to pay any gift taxes, but I would have to report that gift to the IRS because it's more than 15,000. Now I have to report that to the IRS. And what the IRS does is they lower my exclusion amount. Oh, you gave away 100,000 or $1 million. So now you no longer have 10.7, or 11.7, you now have 10.7 that you can give away. They keep a running tab of how much exemption, how much you've given away during your lifetime. So that's how that works. But 11.7 is the number today. Now, many think that that's going to change under the Biden administration because he's talked about wanting to make some tax reforms. That 11.7 went up to, well, it went from 5 million to 11.7 with the Trump's change in the law in 2017. So many people think that Biden's going to try and and take that back and go back to only a $5 million exemption. We don't know today what's going to happen, but we know that today it's 11.7. All right, so another question, do you recommend creating another trust if you relocate to another country? If your living trust was created in the US? Yes, there are different laws. Each country has their own succession laws, estate succession laws. So you definitely want to, even if you have property in another country, you should do not only an estate plan here, if you have assets here, but an estate plan in another country. You should have, because each country has different laws. What's the cost for a living trust for someone that owns properties out of state? So the properties, if you own properties out of state, it's the cost of the estate plan is not different. It's just you have to now incur the cost of titling those properties into your California trust, which we help our clients with. So there's it's just a matter of doing a deed. Sometimes the cost for doing an out-of-state deed is a few $100s, right? Typically to do a deed for a property in any other state to get it into your California trust. So we help clients not only fund the trust with their California properties, but we help them to get their out-of-state real property in the trust as well. We'll talk a little bit more in a second about what the cost is to do a complete estate plan. Does the $500,000 tax exemption still exist? How does it help a couple that sells, particularly if they bought a home years back for $200,000, now worth $1 million? So you're talking about the exclusion from capital gains for the sale of a principal residence. Yes, if you're a married couple, you can, if you sell your principal residence and you've lived in that principal residence for at least 2 years out of the last 5 years, then you could qualify for that homeowners, that exclusion amount, that exclusion from capital gain under Section 121 of the Internal Revenue Code. So you get to exclude the first $250,000 of gain. If you're married, of course, you double that up and you get $500,000. So yes, that is still in place. But another thing that Biden is a target for Biden. He wants to eliminate the capital gains or the capital gains exclusion, that $250,000 exemption. So we don't know what's going to happen with that, but for now it's still there. Yes. If the property is held in a family trust, do we still get 100% stepped up basis if one spouse passes away? Yeah, but whether it's held in a trust or not is not determinative. What's determinative is if you can prove to the IRS, whether it's held in a trust or not, if you can prove that it's community property. If it's community property and you can show the IRS either on title that you took it as community property or that you have an agreement with your spouse that everything you own is community property, you get a stepped up basis. What's the difference between an executor and an administrator? So an executor is the person who is appointed under your will, right? In a probate, the court appoints an executor, that's under a will. The administrator is in the same thing. It's a probate, but there is no will. With an administrator, there is no will. And so the court appoints somebody. They don't call it an executor because there's no will, but they call it an administrator. But it's the same thing. They're both personal representatives of the estate. So it's really a court-appointed person, one where there's a will involved and one where there's no will involved. But their powers to administer the estate in a probate are the same. All right. Because of the new law that was passed in California, should the children not living in the income property sell the property immediately after they acquire the estate property to avoid the higher property tax? Well, look, I mean, the children are going to have to make that decision at that time. So Prop 19, as you know, now has eliminated a big part of the property tax exclusions that were there before. Transfers between parent and child, as you know, were under Prop 58 excluded from reassessment for many properties, for your personal residence and also for income properties up to $1 million of assessed value. So that $1 million of assessed value exclusion is completely eliminated. Now the only exclusion left is where it's the principal residence of the parents and the principal residence of the child. And so, you know, that for many situations, it's not going to happen. Most children have their own homes. And so, yes, they're going to have to be a property tax reassessment now at the death, and the children are going to have to decide whether or not they want to keep the property and pay higher taxes or sell it. And of course, the sooner you sell it after the death, then the less property taxes you'll pay, increased property taxes, because the property taxes will increase as of the date of death. One more question I'm going to answer, and then I'm going to move on. So when a property is vested as joint tenancy, how do we change the vesting to community property? Does that involve a reassessment? No. The way you change it is by filing a quitclaim deed. So the joint owners of the property, the husband and wife, can just file a deed taking it from joint tenancy to husband and wife as community property, or community property with right of survivorship. There's no reassessment on that. It would not be reassessed. Okay. All right. Will the trust prevent the lawsuit against the beneficiary? No. When you create a trust yourself and you put your property into the trust, there is no asset protection. A regular revocable living trust where you're just trying to avoid probate does not give you asset protection. So no. But if your trust is set up properly, and when you pass away, the property goes to your children, you can, if your trust is set up properly, that does give them asset protection. And so they can have asset protection if your trust is set up properly. But I will tell you, 99 out of 100 trusts don't have that kind of protection for their children when they pass away. So it's got to be set up right. All right. Is the out-of-state property held in an LLC? How do I include in the living trust? It's easier if property is held in an LLC. You don't have to change the title to the property because the property is already in the LLC. All you have to do is do an assignment of your LLC to the trust. And it's done by a simple paragraph in a document that says, I own this Paul Velasco LLC, and I'm hereby transferring that LLC to my trust. And that's it. We do an assignment of the LLC and we avoid probate that way. So you don't have to change the title of the property that's in the LLC, just assign the LLC to the trust. All right, so I'm gonna now move on. All right, so let's talk about some of the most common mistakes that people make when they set up a living trust. So what's the primary purpose of a living trust? Remember, we talked about it being a will substitute. It does the same thing that a will does. It allows you to name the beneficiaries who are going to inherit from you, right? So that's the primary purpose, is to avoid probate. But a living trust is a contract, right? So we're giving the trustee of that contract the authority to carry out the terms of the contract when you pass away. When you pass away, property that's in the trust is going to give that trustee the power to collect that property at the bank, to deal with your property that's in a trust, your real property. All of that trust gives them the authority. But it only is going to work, it's only going to be effective if the assets are titled in the name of the trust. If you do a trust, and think of your trust as a box that you created during your lifetime, and in that box, you put all your assets because you retitled everything into the name of the trust. Well, your successor trustee has the key to that box. That trust document gives them the key, and now they have access. But what if when you pass away, you didn't have anything in the box because you didn't title things in the name of the trust? The box is empty. That trustee has no power over those assets. There's nothing in there. So the trust is only effective for what you put into the trust. So a trust has to be properly funded. You have to change the title. And I will just tell you, many people do not. And when you fail to properly title your assets in a trust, it's a ticket to probate court, right? People end up in probate court. How does that happen? How does it end up in probate? Here's why. So when you create your living trust, if your estate plan is done correctly, in addition to the trust, you're also going to do a will. So it's not enough just to do a trust. You also want to do a will. Well, why would you do a will if a trust already says where everything goes? So the trust does all the heavy lifting to get everything to your beneficiaries. You do it as a backup document. Your will says, if at my death, there's anything that I left in my name, then I leave it to my trust. So we call this a pour over will because it pours everything to the trust. So the will is only there as a backup document. So if when you pass away, you properly titled everything in the trust because it was there and you did everything correctly, the will we will never use. But I will just tell you, in most every single case where somebody has a trust, almost without fail, when someone dies, there's something that wasn't in the trust that should have been there. Maybe because they didn't put it in the trust to begin with. They just signed the trust and they put it away. Maybe they did put their things in the trust when they initially created the trust, but some years down the road, as people go through life, they acquire new things. They buy a new property, they open up a bank account, they buy a stock, they start an LLC, and they just forget to put that into the trust too. They just leave it in their name. And now when they pass away, it's not in the trust. So the will is going to catch those things and put it into the trust. But what did I say happens with all wills? All wills are subject to what? To probate. So that's the problem. So now you pass away, you inadvertently left something out of the trust, the will catches it and then puts it into the trust, but you first have to go through probate and then it'll end up in the trust. So how do we avoid that problem then? And I will tell you, it happens. Even my clients make mistakes. My clients will buy new properties or they refinance their current property that was originally in the trust, and the refinancing, sometimes it comes out of the trust back into their individual name and then it never gets put back. They pass away and the property is not titled in the trust anymore. So how do we avoid probate in those situations? We do it by relying on a case by the name of the Estate of Hegstead. This was a case that was decided back in 1993, in which a gentleman, Mr. Hegstead, did a trust. He created a living trust and he titled most of his property, including other real estate, into the trust. But there was one thing that he left out, and that was a property that was still left in his individual name. He never changed the title formally. So when he passed away, they were going to have to now probate that will, right? He did have a pour over will. They were going to have to go through probate. Instead, a very smart attorney, instead of filing the petition for probate, he filed instead a petition in the trust court. And he asked the court to recognize that it was Mr. Hegstead's intent to put that property in the trust too. He just inadvertently left it out. Well, how do we know that Mr. Hegstead intended to put that property in the trust? Because at the back of the trust, he had a schedule of assets. He listed all the properties that as of the date he was signing the trust, he intended to be part of the trust. So the attorney pointed to the court's attention that list and said, Your Honor, we believe that by putting that property on the list, he effectively added it to the trust. We want the court to issue an order stating that that property is part of the trust in accordance with Mr. Hegstead's intent so that we don't have to probate the property. And guess what? The court granted that petition. That set a precedent 28 years ago that now if the court knows what your intent is, we can avoid probate. But you're only going to be able to do that if your trust has the right provisions to take advantage of it. So what should happen now? What should we do? What should every trust have? Let me go back. What should every trust have in order to avoid probate now? What I'm trying to show you is this. In every single trust now, what we do is we have a schedule of assets, right? That case was about having a schedule of assets. At the back of the trust, we do a schedule. We list all the properties that our client owns at the time that they do that they do the trust. We do a list. Their bank accounts at Bank of America, Chase, their real estate title as follows. We do all of that. Their LLC. Then we do not only all of that, at the very end, we do a catch-all that says not only these things that I own as I showed above, but anything else I may acquire in the future, such as real estate, investments, timeshares, copyrights, bank accounts, stocks, a non-exhaustive list of things I may acquire in the future that I would also intend to be part of my trust. So even if my clients make mistakes in the future, I use that schedule of assets. I even do a statement of intent in my trust that says, my intent in doing this trust is to avoid probate at all costs. If I make a mistake, if when I pass away, there was something that was inadvertently left out of the trust, I want the court to issue an order like they did in that case, the Estate of Hegstead. I even cite that in all of my trusts so I can show the court later what the intent was. Give us the same result as you got in Hegstead, and that way we're able to avoid probate. In the 23 years I've been doing this, not once, not one time has one of the estates that I've represented had to go through probate, where it was our documents. We were able to rely on that form, all right? So that's the Estate of Hegstead, and that's how we avoid problems. All right, guys, well, I see that my time is just about up. There are other things that I wanted to be able to share with you today. I just don't have time. I could give you, I want to be respectful of your time, so I'll leave it up to you. If you want me to go another 10 minutes, I can talk about something else. But if not, we can end it here, maybe just answer a few questions. And you tell me, Mario or Pauline, how you want to do it.
We want to listen more. Thank you.
You want to listen more? Okay.
Yes.
All right. All right. So let me go through this one other thing here. Just bear with me, and I'll give you some important information that most people are not ever going to tell you. So here's a case study. I'm going to talk to you about Mike and, remember the Brady bunch? Here's Mike and Carol Brady. We've updated them a little from the 70s, but here they are, Mike and Carol. So they have assets. They've got their home, rental properties, some mutual funds, retirement plans, some life insurance. They have a total estate of $2.2 million, right? The value, this is an arbitrary number, right? It could be $20 million, it could be 500,000. The concepts that I'm going to talk to you about are the same. So Mike and Carol come to me and they want to do a trust. So when married couples are doing a trust, there's not just one type. There's not a one size fits all. There's different options for a married couple to set up a living trust. And each option has different consequences, right? What we're trying to do is answer this question. What happens with the trust when the first spouse passes away? Because a trust is going to control things in 3 phases of a married couple's life. The first phase is during their joint lifetimes. Remember, that trust is a contract. That contract has provisions that say when we're both alive, we can use this property however we want. Remember, the trust is revocable. They can change it. They can revoke it. They can cancel it entirely. They have complete control. They can use and spend the money however they choose. That's the first phase. The second phase is what happens with the trust when the first spouse dies. What happens? It depends. It depends. Can the surviving spouse revoke the trust? Can they change the trust? Can they amend the trust? What about the survivor? Can they just use and spend all the money that's in the trust? Or what if the survivor remarries? Could they leave it all to a new spouse? Are the children protected? All of that depends on the type of trust you choose. So let me go through the options with you. Here are the different types of trust that people can set up. And let me just tell you, when I sit with clients who already have a trust and who come to me and want me to review their trust, 99 times out of 100, they have no idea which option of trust they have. When I sit there and talk to them and tell them and I read the trust and I say, this is what will happen when the first spouse dies, most of the time they had no idea because the attorney never explained it to them, never gave them a choice. The attorney just chose for them. But here are the options. Number 1, an AB trust. An AB trust works like this. So if you look at the top box, Mike and Carol Brady Living Trust, that is what the trust looks like. Ignore everything below that. That is what the trust looks like when you create the trust initially. All you're doing is creating this trust and you're putting everything, all your assets. So in that box is all their assets, their investments, their property, their bank accounts, everything is in there. And during their joint lives, they could use it however they choose. But when the first spouse passes away, an AB trust says, surviving spouse, you need to now split this trust into 2 trusts, known as the survivor's trust and the decedent's trust. So now the Brady Family Trust is no longer going to exist like it was. It's now going to be 2 separate trusts. And this is going to now have to retitle all the assets so that half of the estate, since this was all community property, half of the estate ends up being titled in survivor's trust and the other half in the decedent's trust. Literally, the survivor will take all the assets, get date of death values for everything, appraisals for the real estate, for the business, bank account balances, everything. And then we say, okay, 2.2 million. We're now going to retitle everything into survivor's trust A and to decedent's trust B. Now it's no longer a single trust, but 2 trusts, each holding 1/2 of the estate. And each of these trusts have different terms. There are different characteristics. So let's talk about the survivor's trust. The survivor's trust represents the surviving spouse's 1/2 of the estate. The survivor can do whatever they want with that half. The survivor can amend the trust. They can revoke this trust. They can spend all the assets however they choose. There are no restrictions on what the survivor can do with that half. The survivor could remarry and leave all these assets to a new spouse. No changes. No restrictions. They can do whatever they want. That survivor's trust remains revocable. The decedent's trust, however, becomes irrevocable. The survivor can no longer change that. So if when Mike and Carol set it up, initially when they created their trust together, they said that everything was going to their children, well, that B trust cannot be changed. Mike's portion of the trust, if he died first, whoever the deceased spouse is, their wishes are set in stone now. So when the survivor dies, whatever is left in that B trust has to go to the children the way it was set up originally. Survivor cannot change that. Well, then what can the survivor do with it? Why is it held in trust? Because nothing goes down to the children after the first death. Typically, everything stays in trust for the survivor. It's there if the survivor needs it for health, support, or maintenance. That is to maintain your accustomed standard of living. If the survivor does not have enough income coming in or assets in the survivor's trust to maintain their lifestyle, they can now reach into the B trust. And because the survivor is the trustee of both trusts and still in control, they still manage both trusts. So they can reach into B if they need that money because there's not sufficient money on their side of the fence to maintain their lifestyle. They can reach into D. So B is like a reserve, a backup, if you will, only if the survivor needs it. If the survivor doesn't need that during their lifetime, then those assets will just stay in the decedent's trust and continue to grow and appreciate, and whatever's left goes to the kids when the second spouse dies. That is an AB trust, okay? You can see that there's some level of complexity with this. There's some level of administrative burdens, if you will, some inconveniences that go along with this type of a trust. Why? Because when the first spouse dies, there is going to be work that needs to get done. The survivor has to follow these instructions in the trust. It's a contract. They have to carry out the contract, and they're going to need help. They're going to have to come back to me or some other attorney who knows what they're doing and be able to help them create these two trusts and then retitle everything into the name of the two trusts. Also, that B trust has to file a separate tax return every year. So in addition to the survivor's individual tax return that they file, they are going to have to file a tax return for that decedent's trust to report the income that comes in for that trust. So you can see there's some level of complexity now to that. That is an AB trust. So let's just summarize real quick. With an AB trust, at the first death, the assets get retitled into A and B. We split the trust into two, survivor's trust and decedent's trust. The survivor is still in control of both trusts as the successor trustee, has control still to manage the assets and to use and distribute the assets, but that B trust becomes irrevocable. Although the survivor can do whatever they want with trust A, they can no longer amend trust B. They can only use the assets if they need it for health support and maintenance, but they cannot change the beneficiaries of B. They can do whatever they want with trust A, they can revoke it, change it. But with this kind of trust comes some administrative burdens. There's work that needs to get done when the first spouse dies. The attorney's going to have to help them set it all up, and that B trust has to file a separate tax return every year. That is an AB trust. Okay, I know you're going to have questions, but I'll answer them at the end of this segment. So here's the second option. The second option is what we refer to as a simple trust. Why? Because it's very simple. It's easy. It's much more flexible, much more ease of administration when the first spouse passes away. So what happens when the first spouse dies with this type of trust? Everything just stays in trust for the survivor. There is no need to split everything up. We don't divide the trust. Everything just stays in trust. So there's very little to do when the first spouse dies. Things just remain in the trust for the survivor, and the survivor is the trustee of that trust. The survivor has complete control. The survivor can use and spend the money however they choose. There's no restrictions for health support maintenance only. They can spend it however they want. The survivor could even change the beneficiaries, not just their half, the entire thing. So even though Mike and Carol in the beginning, when they set up their trust together, it said that when they both died, it would go to all the children, the survivor could change that. The survivor could leave it all to one child. The survivor could leave it all to a new spouse. The survivor could cancel this trust completely, take all the assets out, and start a new trust somewhere else. There are absolutely no restrictions on what the survivor can do with this trust. That is a simple trust, right? Now, with any other attorney you go to, this is it, folks. You're only going to get these two choices, a AB trust or a simple trust. That's all there is out there. But over the years, I've heard my clients complain many, many times that these two options are not appealing to either of them, right? Either of those options. Why? Because they don't like the complexity of that AB trust and what the survivor is going to have to do when the first spouse passes away. But that simple trust gives the survivor too much power to just give it all away and leave it all to a new spouse. And people don't like that. Even married couples where there's not a blended family, where it's one marriage, a long-term marriage, children of the same marriage, there's still that concern that, you know, if one of them passes away, that the survivor may get duped by somebody, right? That trophy wife that comes in and just takes everything away from the children. So there's concerns about that. And this simple trust doesn't address those concerns. So they always ask me, isn't there something in between? So about 8 years ago, we listened to our clients and we developed something in between. We created what I refer to as a hybrid trust option. We listened to our clients. Remember I said a trust is a contract. I can make the contract say whatever my clients want it to say. So let me just, before I talk to you about the hybrid trust, let me just review with you quickly the simple trust. So remember, with this simple trust, there's no division of the trust at the first death. No administrative burdens, very easy. The first spouse gets everything, they can do with it, whatever. The surviving spouse retains everything in trust. There's really very little to do when the first spouse dies. We don't have to change all the titling of the assets. Things just stay there. The survivor has complete control of this trust as trustee, no restrictions on what they can spend it on or use it for. And the survivor can amend the trust, not just their half, the entire thing, 100%. They can change the entire plan. Obviously, this is not a good option for blended families where you have children from different marriages, right? Because the survivor could just leave it all to their children and cut out the deceased spouse's children. So not a good option, but this is an option there. So that's option number 2. Option number 3, as I said, is what I referred to as a hybrid trust option. The reason I call it a hybrid is because it is a combination. The features of this trust are a combination of those other 2 trusts that I showed to you. So here's how it works. So hybrid trust looks much like that simple trust option, right? So when the first spouse dies, there's no division of the trust. Everything just stays in trust for the survivor. So the survivor does not have to split everything up, and the survivor is in control of the trust as the trustee. But unlike the simple trust option, this trust now becomes irrevocable in the sense that the survivor can no longer cancel the trust, can no longer cancel it and take the assets out and start a new trust. No, you've got to leave the trust in place. So that trust has to stay there throughout the survivor's lifetime. Now, the survivor still has control and can still use and spend the money the way the survivor wants. So in other words, consume it. If they want to go on a whirlwind trip through Europe for 5 years, they can do that. If they want to spend it all that way, they can spend it. No restrictions on spending. But what they cannot do is take assets out and leave them somewhere else. Take assets out and put somebody else on title with an account for them. Put somebody else on title on the property. No, you've got to leave the assets in the trust unless you're spending or consuming them, okay? You've got to leave the assets there. You can't take it out and you can't cancel the trust. Now, the survivor could sell a property, no problem. You could sell it, you're the trustee, you can sell property, but the money's got to come back into the trust. You can sell a property and buy another property. You can sell a property and buy stocks. Those things have to come back into the name of the trust. So you can change assets in and out, but you've got to leave them in the trust. Don't leave them somewhere else, okay? So that's the first thing. Then where does everything go when the survivor dies? Well, in the beginning, when they created the trust, each of them, Mike and Carol, told me where they would want their half to go. Now, in their case, because they just have children of the same marriage, they each said to our children. So in the trust, initially when we created it, it says Mike's half goes to the children, Carol's half goes to the children. But the surviving spouse can still amend their portion of the trust. Where do their 50% go when they pass away? They can still change that. They can amend it, but they cannot change the deceased spouse's provisions. So that for sure will end up going to the kids when the second spouse passes away. So that looks much like that AB trust. Remember where the survivor couldn't change the deceased spouse's wishes? But this happens at the end, at the back end. So the survivor doesn't have all of those burdens of having to split everything up at the first death. No, everything just goes to the survivor at the first death. But now the survivor, essentially what this trust says is this: honey, if I die first, I'm leaving everything to you in the trust. You can use and spend it however you want, but don't take assets out of the trust, leave them there unless you're spending them, and you cannot cancel this trust. When you pass away, at least half of what is left has to go to the kids the way we set it up originally. If you want to change your half, you can do that. That is the hybrid option, right? So just to show you real quickly, no division of the trust at the first death, very few administrative burdens when the first spouse dies. There's not a whole lot that needs to get done. The survivor is in complete control as the trustee of that trust, and there's no restrictions on how the survivor can consume or spend the money. They can use it. No health support maintenance standard. But the survivor cannot revoke the trust or cancel the trust anymore. They cannot cancel or move assets out of the trust either. You got to leave them in the trust. And the survivor, if they want to amend their provisions for where their 50% would go when the survivor passes, they can only change 50%, not the other 50%. That is the hybrid. You can see how these three options are so very different. And I don't know how any attorney can choose any of these options for the client. Each client should be able to make their own determinations and decisions about how to set up a trust like this. It has to be explained to them just the way that I'm explaining it to you. And then they can decide what is best for them and their family. That is how those trusts work, okay? And this is a mistake that people make. Married couples do trusts all the time without knowing which option they've chosen. Most often, they've chosen that AB option, and often it's not what they would have wanted. So that is how that works, all right? So let me just answer a couple of questions and then we'll end this. When should the AB trust split to AB? It happens when the first spouse passes away. The first spouse dies, that's when the trust gets split into two, when it's an AB trust. Automobiles, do they need to be titled in the name of the trust? No. You don't need to put the title of your car, your automobiles into a trust. They can stay in your individual name. Those titles are easily transferred later at the DMV without requiring a probate. There's simple forms that can be filled out. What a good concept on the non-amendable clause to replace restrictions. I think people are saying, applauding the hybrid trust. Yeah, it's my most popular option now. People choose that. Most people don't want to do the AB trust, but they also don't like the fact that the survivor could change the entire plan. They like that there's this flexibility, that we give flexibility to the survivor. Yes, you can use and spend the assets the way you want, but you can't just start giving everything away. You've got to use it for what you need. All right, so somebody asks here, my PowerPoint, can we give that to you? Yes, I will send that over to Mario or to Pauline, and you guys can have my PowerPoint presentation. There's more information in here. Unfortunately, there's not enough time. Maybe on another occasion I can share other information. So let me just tell you briefly about what are the costs of setting all this up. So I don't charge for initial consultation. So anybody can come to me and they can talk about how to set up a trust, answer questions. I can share much of the information I've shared with you. I don't charge for initial consultations, even if somebody already has a trust and they just want me to review their trust. Come in, meet with me. I think this information is important. So I sit down with you. I give my clients a questionnaire, fill out this questionnaire, bring it with you so that I can know more about your family and your finances. Then I can help make recommendations to you. I would tell you what recommendations I have for you, and then let you know how much we would charge to do the estate plan for your trust. For most people, you can see here what a complete estate plan includes. It's not just a living trust. You also have to do those pour over wills. Remember I said each plan, when it's done correctly, you also have to have a will as a backup document to catch anything that was left outside the trust. You also have to have a power of attorney in case you become incapacitated so that people can make decisions for you, file your tax returns, deal with Social Security, deal with the lawsuit or anything that you can't deal with anymore. Same thing with your healthcare decisions using the Advanced Healthcare Directive. Remember that property agreement that I said, the importance of having a community property agreement that we can show the IRS that says, hey, we considered everything we owned to be community property. So we get that stepped up basis. That's what that property agreement is for. So these are the documents that comprise a complete estate plan. An average cost for an estate plan for a single person is about $2,500. And for a married couple, it's $2,900, $25 and $29, okay? If they have more real estate that has to be put into the trust, we have to prepare deeds. We charge about $150 per deed beyond the first two properties that they have. So they have a residence and a rental property, that's included in that flat fee that I just quoted you. They have more, it costs a little bit more to do those deeds. All right, so this is where our offices are. We have offices in Long Beach, Downey, and Irvine. Feel free to reach out to us. Look, use me as a resource as well. If you just have questions or something comes up with your clients or there's an issue or titling issue where somebody's passed away, feel free to reach out to us and we'll be happy to answer your questions or give you some guidance.
Thank you so much, Mr. Velasco. Extremely powerful presentations. Most definitely, I will contact your office. So I'll pass this on to Pauline. We thank you so much for your time. Pauline,
all right, you're welcome. Thank you all.
I want to say thank you. Thank you very much. What a great spring we have your presentation with us. Thank you so much, Paul and Mario, for this fabulous section. If you have any further question for estate planning, please contact Mr. Paul Velasco directly. And so we learned today the different type of trust, all the important features. Hope this will benefit you and your clients, and no hesitation to ask Attorney Paul Velasco at any time. And on behalf of West and Gabriel Valley Realtors, we would like to thank again Attorney Paul Velasco from Velasco Law Group for your wonderful, your expertise and your valuable presentation to our members and fellow realtors today. We hope to see you in person very soon. Come to our association. We want you to come back again to give us more education about living trust and the other topic. And a quick reminder, tomorrow, 2 o'clock, we have another good section for you. The topic is Power of Preparedness by the founder of CKM Solution Group, Ms. Connie Myers. She will bring you a lot of important matters and ideas when we face this new norm, how we can emphasize and give us a lot of injection in our knowledge and our attitude to fit in new situation and new real estate markets. So we wish to see you tomorrow, 11 o'clock, and then register at wsgvar.com. Choose education schedule, and see you tomorrow at 11. And we want to thank again Paul, Mario, and Fong, and all of you. We joined together this morning. It's a wonderful and happy section. Thank you, Paul.